focusing on is not only this video evidence, but the statements as well, right?
I certainly reviewed the statements that I was provided.
And then within that, you're also reviewing some of the statements the officers made as well, right?
Absolutely.
And so what you're essentially trying to do is look at all these statements and kind of put together what is occurring.
No, I wouldn't say that I do that, because I think that's really what the jury has to do as far as deciding who's telling the truth and what the credibility is and who observed what. What I'm trying to do is put together a background story, as generally any expert report does. Okay. And I try to include whatever versions of events there are in the case.
Okay. And you included some of the summaries of statements within your report as well?
I did.
Okay. And so you didn't include Chad Hayes, though, in your report, did you?
I did not.
Despite the fact that he was an eyewitness in this case?
He was, but I don't think I included Mr. Lowry either, because I found the story, the version he was providing was similar to, I'm sorry, I forgot her name. Miss McDowell, and I found that Kenneth White, talked about some level of resistance the same way Shad did, so I incorporated the story.
But each officer that gave a statement, when you review it, obviously you would agree with me, they perceive or see things from their perspective, right?
From when they arrive, and they could have different perspectives.
Right. So you can look at each statement and see, okay, well, what does he or she see upon initial arrival, right?
Correct. Whatever they reported that they saw.
Okay. Like we talked about Trooper Casey Jones as well.
So Trooper Jones, says he sees him in prone restraint from the time he's there till the time he finishes, I think. Yeah.
Well, that's not all he said, Mr. Ryan, right?
No, that's correct. We talked about what he said.
Okay. Yeah. But that's the only thing that you just mentioned right now on the stand. Is prone restraint from the time he's there to the time he leaves?
Well, that's he does describe it that way.
Well, what else does he describe?
He describes some yelling and banging the head on the ground.
Okay.
But we talked about that already.
Okay. Well, you didn't just mention it. That's why I'm saying that's
okay.
Not all he describes. I'm trying to present a holistic of what everyone sees, right? Not just picking and choosing information out of each statement. Do you think that's fair?
Overruled. I don't think
that's a fair process?
I do think that's a fair process.
So I want to get more into the statements, but let's set the background for Officer Rankin here, because I think on direct you testified that he was a police officer starting in 2018, I believe.
Whatever the document said, I was presented with a document, and I went by the document date.
Okay, so I want to hand you what's been marked as Exhibit 73, if I can approach, Your Honor. So this is Exhibit 73, and I'm going to draw your attention to the second page there. And there are a number of dates that are indicated on there for when Officer Rankin attended the Criminal Justice Training Commission Basic Law Enforcement Academy. Doesn't it indicate it in there?
I'm trying to see it. I don't see that, and I apologize.
That's okay.
Oh, I see the higher date is 8/6/2018.
Okay. And right below it?
Commission date is 1/29/2019.
Okay. Does it indicate the I think it's called BLEA for short, BLEA?
It does. It says Washington Criminal Justice Training Basic Law Enforcement Academy number 776.
And what are the dates that he attended the Basic Law Enforcement Academy?
Looks like September 18th, 18 to 1/29/19.
Okay, so 1/29/19 is when he, pursuant to that document indicates when he graduated the basic law enforcement academy, right?
Pursuant to this document, yes.
Okay. So this incident happens March 2020, right?
Correct.
March 3rd, 2020.
Correct.
So he had graduated the basic law enforcement academy roughly a little over a year prior to this incident, right?
I'd say 14 months, 15 months.
Okay. And so there's also indicated in there when he's on what I think it's indicated as probationary patrol.
Correct.
Indicate that?
Yes.
And what are the dates? Well, do you know what probationary patrol is?
Again, it generally means that for a year you can be subject to release from the agency. For a whole year, you're on probation before you get permanent status.
It's not something that, it's not he's done something wrong, it's that he's a new officer, right?
Correct.
He's a brand new officer, and that he's going to have someone that's going to do a ride along with him for that period of time. Is that?
I don't know that it's the whole year. Again, patrol probation would generally mean something different, but that PTO could be this similar to being with a training officer.
Okay, and so what are the dates that he was in that probationary patrol PTO program?
It says 11/5/18 to 1/28/2020 on this document.
Okay, 1/28/20 is when he's off of that initial new officer probationary patrol.
That's what this document says, yes.
Okay, so roughly a month? No, February. Yeah, we have February, right? 28 days. Actually, I did it the other day. 28 days prior to this incident, he gets off his probationary patrol as a new officer.
Based on this document.
Okay. So the other thing, I can take that back if you want. Thank you. So the other thing you talked about is kind of the hours that it takes to become a police officer. I think you said it was 720 hours.
Correct.
Okay. And you go around, it sounds like, the country giving trainings to various police agencies, right?
That's correct.
Okay. So it sounds like you're familiar with the training requirements nationwide.
Yes.
Okay. You haven't done training here in Washington area since 2016?
That was the last one that I saw.
Okay. And how would you say that the United States does in terms of training compared to other countries for our police officers? Absolutely relevant.
I'll sustain the objection. I agree with the state.
Okay. Well, let me ask you this. Are you aware that in Washington State, it takes 1,600 hours to be a cosmetologist?
Objection on irrelevance.
I think it may be fair to say that's outside the expertise of the witness.
It might be.
And so I'll sustain the objection.
There goes that check.
It's beyond my knowledge, too, if that'll make anybody feel better.
Sure. So let's talk about being a police officer. Dangerous job, right?
It is.
Okay. There are, within our community, there are first responders.
Absolutely.
Okay. And, we expect out of officers that when there is a dangerous situation, say a school shooting, for instance, that they're going to be running towards that dangerous incident and protecting and serving.
It's an embarrassment when it happens any other way, as we've seen a couple of times.
Okay. And so where someone starts shooting, I'm going to run this way, right? We're expecting our officers to run that way towards the danger.
Absolutely, in that kind of event where there's innocent people at risk, absolutely.
Okay. And I mean, that's just one example of the dynamics of the job that we ask of them, right?
Well, that's a very particular kind of active shooter situation where we expect officers to take immediate action
Okay.
and take the risk.
Well, let's think of another example. Say that there's someone extremely high on drugs and is a danger to themselves and others. We would expect police officers there in that scenario to essentially handle that situation, right?
To a degree, if there were innocent people, again, we do what we call tactical decision-making, and so if there's hostages, if there's innocent people, then certainly the officer is going to place themselves between, potential victims and that person if the person's a danger to somebody.
Okay. And so that the idea behind the dynamics and dangerousness of that job, you talked about the Graham factors, that Supreme Court case, Graham v. O'Connor, right?
That's an analysis for use of force, yes.
Okay. And so you're familiar with the ruling within that case.
Of course.
And so, the factors, and actually what the case says is the proper application of Graham requires careful attention to the facts and circumstances of each particular case.
Of course.
Including the severity of the crime at issue, right?
Of course.
Whether the suspect poses an immediate threat to the safety of officers or others.
Correct.
And whether it says he here, but I'll say he or she is actively resisting arrest or attempting to evade arrest by flight.
Absolutely.
Those are the factors that Graham says you should look at.
Absolutely.
And then it goes on to say that the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on scene rather than with 20/20 vision or hindsight, right?
Correct.
Meaning, okay, you have to take into account what they're presented with in that moment. Because the next thing that the case says is not every push or shove, even if it may later seem unnecessary in the peace of a judge's chambers, right, violates the Fourth Amendment.
Absolutely.
Okay. And so that's kind of embodying this idea that, you can't Monday morning armchair quarterback a situation because of the dangerousness and the dynamics that these police officers face. Correct?
No, that's not really what it means. It means, again, 20/20 hindsight means you've got to take the perspective of what was known to the officer at the time and then apply that to an objectively reasonable officer. Would they have done the same act? You can't take what they learned after the fact to either help them or hurt the analysis.
Oh, because I thought you testified earlier that it was an objective perspective, wasn't knowledge-based. Did I misunderstand that?
No, I said it wasn't subjective. In fact, if you read further, I think you'll see that it says that the officer's motivation is not considered.
I read it. So the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. That's what the case says as well, right?
Absolutely.
And it says reasonable officer. So, and from that perspective, a reasonable officer is the reasonable officer given the training, experience, facts that they know, and the perception known to that officer at the time.
Correct. Not what they learn with 20/20 hindsight.
Right. So not what they learn later on that an individual has heart disease and a dilated heart, right?
Correct. That would not change the evaluation of the use of force at all.
Or lethal amounts of methamphetamine in their system.
Would not change the use of force at all.
Okay. And what's interesting about Graham and what I find a bit puzzling is that Graham is a civil case, right?
Objection, Your Honor.
Sure.
Objection is a form of a question.
I haven't,
Is he testifying? Why I find it puzzling?
well, I'll call it foundation, I'll allow him to proceed, continue.
Okay. Graham is a civil case.
Graham was a civil rights lawsuit alleging a violation of the Fourth Amendment, excessive force, but it was a civil case for money, not a criminal case. And really what was at issue was, again, I don't know if you want me to get into this, but what was at issue was there was various courts.
I'll allow Mr. Conrad to let us know whether he wants to hear
You know
some more.
what? Sometimes I find it a bit amusing, but my question really was kind of yes or no, believe it or not. So it was a civil case, right?
It was a civil case where they had to look at how use of force was analyzed, yes.
Correct. And you mentioned this, but civil is a different ballgame than criminal, right? In many respects.
In some respects, but when it comes to use of force, it's the standard that law enforcement applies, whether it be civil, policy, and even criminal cases.
Well, this Graham standard that you are applying to this case, right? You understand that in this case there will be jury instructions, right?
Absolutely.
All right, and the judge is going to inform the jury as to what the law is.
Correct.
Okay, and so there may be many differences, obviously, in a criminal case versus a civil case, correct?
But again, we were talking about Graham in terms of police practices, because this is the standard that we see applied in police practices, including the Tacoma policy.
Okay. But ultimately, you'd agree with me that obviously Judge Chiscoff is going to inform the jury of what the law is in this case.
Absolutely. I'm not instructing on the law. I'm instructing on the police practice.
Okay. So, since we're undertaking the Graham standard, let's talk about the seriousness of the offense, right? The severity of the crime at issue. Knowing, given the training experience, knowing what Officer Rankin knows at this time. That's the lens I want to look at this through, okay?
Sure.
So, what we know is that Officer Rankin and Officer Ford are partners, right?
Yes.
They had just backed up Officer Burbank and Officer Collins on a previous stop.
On a traffic stop. That's right.
And then they went their separate ways, right?
Correct.
And then Officer Ford and Officer Rankin, they were preparing to make a stop on a vehicle that they suspected was picking up people or doing something suspicious, correct?
Correct. I forget exactly what it was. I don't know if it was drugs or prostitution, but there was something that they saw.
Correct. And then all of a sudden, there's these mic clicks that are happening.
Correct.
And as an officer, you're taught that the microphone that you're using, right, the radio, is something how you communicate with your fellow colleagues and officers, correct?
Of course.
And so when you use it, you're going to use it to say something, not just click it for fun, right?
That's correct.
All right. I mean, inadvertent mic clicks happen.
No question.
But when you have multiple mic clicks, like in this case, it starts to cause a bit of a concern. Do you agree with me?
It certainly could, and I think they articulated as it did in this case.
Right. And so you get these mic clicks, and we know that it's from Burbank and Collins' vehicle, at least one of them. I forget who it was.
You know, I don't know if it was the vehicle, or I think it was their portable radio on their person.
Correct. That's what I meant. So we know it's from either Burbank or Collins. Within there, one of those officers are clicking their mic.
Correct.
Okay. And then we know that dispatch gets over the radio, and dispatch is a separate entity, obviously, or a separate person that's asking, hey, what's going on? You have radio to Burbank and Collins and asking for a response, right?
Correct.
And there is no response.
Correct.
Okay. That's also concerning, right?
Of course.
That if it was an inadvertent mic click, they'd say, no, clear, I don't know what they'd say, but they'd say, clear, it's not an issue, right?
Correct.
But they don't get that.
That's right.
And then you have one response at a certain point. 96 in Ainsworth. That's Burbank coming over the radio, right?
Yes.
He says nothing else other than 96 in Ainsworth. And so dispatch is asking for more information, and again, there's no response.
Yes.
So the only thing Officer Ford and Officer Rankin know at this time is that they have their fellow officers who are having empty mic clicks, have yelled out 96 and Ainsworth, and are not responding, correct?
That's correct.
Overruled.
So, at this point, Officer Ford and Officer Rankin turn around and they start heading towards 96 and Ainsworth.
Yes.
And you'd agree with me that this is a concerning situation for these officers in this scenario, right?
I think any time you think an officer could be in trouble, it's a concerning situation.
And when they arrive on scene, they see Officer Burbeck and Officer Collins, their vehicles in the middle of the street with just the ambers on, right?
Yeah, I don't recall if they saw the ambers on or not. I think they said the door was open or something like that too. There was something else that was a flag to them.
Okay.
They spotted the car.
Again, another cause for concern.
Until they find out further, sure.
Sure, they don't know what's going on.
Correct.
I mean, you read Officer Ford's statement, right?
Yes.
Officer Ford says, I was thinking the worst.
He does say that.
And because one of the reasons that he says that is because both Officer Ford and Officer Rankin have trained with Officer Burbeck before, right?
That's right.
I mean, he was actually one of their training officers, I believe.
I'd have to look back at that. I don't recall that.
And they say that they have never heard Officer Burbank yell out over the mic like that before, and that was very concerning to them, right?
That's what they report.
Okay. And so when they arrive, they see this vehicle, ambers on, and they don't see Officer Collins or Officer Burbank anywhere to be seen at that moment, right?
Initially, they do not.
I think Officer Ford even talks about the fact that he even checked his heart rate at that point, and his heart rate was pretty elevated, right?
I don't know. He might have said that. I don't know why anybody would do that, but if you were trying to get to an officer, but it's possible. I don't know.
Kids these days, they have those heart monitors on them. So I think Officer Ford says he gets out of the vehicle even before it's even come to a stop yet. He's running over there to help, right?
I know they get out right away and approach the scene, the two of them.
Okay. And what they see when they arrive is Officer Burbank and Officer Collins struggling with Mr. Ellis.
I think that's what they report, yes.
And they see that Mr. Ellis is kicking at the officers or struggling and resisting, right?
I think they say he is struggling, without question.
All right. And in fact, Officer Ford says, given the amount of struggle that Mr. Ellis was putting up in that moment, he didn't even think that he was in handcuffs.
I think he did definitely question whether he was in handcuffs yet, and determined that he was, but not initially.
And Officer Ford then goes, and he's the first person to arrive on scene. I think Officer Rankin's a bit behind him, right?
I'd have to look back at their statements to see that.
And Officer Ford starts helping by restraining Mr. Ellis's legs,
Yes.
right? Because he sees Officer Collins is trying to grab his leg, so he's like, well, I'm going to grab a leg and let's hold on to this guy, right?
Correct.
And he says, actually in his statement, he says he's just kind of holding on for dear life while he's getting rocked around, right?
I think he reports that in his statement.
Okay. And then Officer Rankin then arrives on scene and is trying to figure out some way that he can help in this situation as well, right?
Yeah, and I think, one of the things he said was he wanted to make sure that he was already handcuffed and made that determination and made sure they were on correctly.
Right. Pursuant to policy.
Well, to make sure they were on correctly, to make sure he's already handcuffed and restrained in that way.
And one of the things that Officer Rankin also notices is that there's a gun magazine on the ground or on Officer or Mr. Ellis's back somewhere, right?
Yeah, I think, and I'm apologize, but one of the officers, his gun magazine dropped out of his vest in the course of this.
You're going 20/20 hindsight, right?
Well, yeah, he doesn't know whose gun magazine it is at that point.
Okay.
Yeah, I mean, he'd have no way of knowing that for certain.
You're right. So that's my point, right? So he doesn't know. He just sees a gun magazine laying down, right?
He does. I don't know exactly what point it was, but there's definitely a gun magazine there.
No one said to him, you know, Officer Burbank or Collins didn't say, hey, don't worry about that, that's mine, it just fell out of my vest jacket, right?
That's true.
Okay. He just sees it there, and I think someone says that they throw it off to the side or something.
Kicked it off or threw it off to the side.
So at this point, what Officer Rankin knows, he knows that his fellow officers, both who he discusses are highly trained, right?
Yes.
Are in a struggle with an individual that is now actively resisting.
That he sees struggling, there's no question.
Okay.
That's what he reports.
He has no idea as to how this incident started, right?
Correct.
It is completely reasonable for him to assume in that situation that these officers have been in a struggle or fight with this individual, right?
Absolutely.
Okay. And now he sees a magazine, and it's completely reasonable for him to think that this individual may be armed as well, right?
If he believed that, the police practice would be to immediately shout out gun or possible gun.
Okay.
I don't know that there's anything in the material that indicates that he did that.
Okay. And so you've talked about Mr. Ellis being in handcuffs at that moment, right?
Yes.
That doesn't mean that he's not still a danger to officers, correct?
Well, now you have to add that into the threat assessment. So obviously, once somebody's in handcuff, the threat comes down dramatically because they don't have use of their hands. One of the things that's said in law enforcement is it's the hands that kill. So, you know, once we're certain that his hands are restrained, then obviously the threat level dissipates.
Well, one of the things that they say in law enforcement as well is that an individual that is handcuffed is still a danger, right?
Can still be a danger.
Right, because I could have my hands behind my back, and that doesn't mean I'm still probably not that dangerous, right, given my stature, but that doesn't mean that I'm not still dangerous in this scenario.
Could be. There's been instances where handcuffed prisoners do cause harm to officers.
Killed them even.
There's been at least one case that I was involved in where the officer was killed, yes.
Okay. So this is kind of the scenario, the gram factors that we know that are in play, at least in terms of the severity of crime issue as to what Officer Rankin knows. Is that fair?
At that first moment, yes.
Okay. And we know that Mr. Ellis is still actively resisting, right?
Again, I think once a person is handcuffed, particularly in the prone position, it's possible they're actively resisting. It's also possible that they're fighting for oxygen, and it's not conscious noncompliance.
Okay.
That's what the training is.
Well, you've looked at the policy, right? The use of force policy.
I have.
Okay. Can we, I believe it's already been admitted for illustrative purposes, 301.
I think it was, let's check. For illustrative purposes only, yes, this morning.
Sorry, did I miss that?
For illustrative purposes only, yes, this morning.
Can we publish 301, please?
You may do so.
Thank you. You know what? Mr. Ryan, I'm going to give you 301 as well.
Yes, sir. Thank you.
Sure. And so this is the use of force policy and procedures, I believe, manual for Tacoma Police Department, right?
Correct.
And it goes through, it's a use of force model, right?
Well, there's a force continuum model.
And the continuum is based essentially on what are the individual's actions and what is a reasonable officer response, correct?
Correct.
And so it starts with, let's say they're compliant. Can you zoom in on this at all? Just the first page, that use of force model, please. Perfect. Thank you. So it starts with compliant. Oh, it's not great name. Compliant, right? And what the reasonable officer response would be cooperative controls, right?
Correct.
All right. And then we have passive resistant. So if the subject's actions are passive resistant, then we have contact controls, right?
That's what this model shows, yes.
And then active resistant compliance techniques.
Correct.
Okay. And can we scroll to this is page 5, please? What we go ahead. Keep going, thanks. Oh, never mind. One more page. Okay, great. Thank you. So here we are on the force model for active resistance and what compliance techniques would be appropriate in that scenario, given this policy, correct?
Correct, but in conjunction with it being reasonable and necessary.
Okay. And can you scroll up just a little bit so I can see the top of the page, please? And so it says active resistance. Use of physical effort or mechanical resistance in achieving and or maintaining non-compliance. That is the definition of active resistance under the Tacoma Police Department policy, correct?
Absolutely.
All right. So if an individual is using physical effort or mechanical resistance in or achieving or maintaining non-compliance, that would meet the definition of active resistance, right?
Under the Tacoma policy, absolutely.
And then the enforcement electives, if we could scroll to the bottom of the page, please. Great. It says, when someone's active resistant, these are the type of things that you can use, essentially, right?
Well, yes and no. It still has to be. These are tools that are available, but you still have to be reasonable.
And you still have to
So,
do it
for example, you know, 40 millimeter launcher is here, which shoots a round out. You know, somebody is pulling away, that would be active resistance under the definition, but you certainly couldn't shoot them with a 40 millimeter round.
couldn't agree more, right?
So it doesn't mean just because they're active resistance, you can use these in all circumstances.
I agree. For instance, Mr. Ellis in that scenario, right? Using a 40 millimeter extended range projectile launcher would not have been appropriate in that scenario. Right?
Absolutely, would have been
Okay.
totally disproportional.
Sure. But that didn't happen, right?
No,
In fact, in that scenario where he is actively resistant, Officer Rankin, he never punches him, right?
correct,
He never kicks him, right?
correct.
He never uses an LVNR on him.
That's correct, he did
Right.
not.
In fact, Officer Rankin and Officer Ford are one of the tools that they talk about, right, is de-escalation tactics by using your words, right?
Correct.
And that means when an officer is saying, hey, stop, calm down, stop doing that, that is a tool that they've been given, their voice, to try and calm this individual down, right?
Those are verbal commands.
Sure. And that is occurring in this scenario as well.
In addition to putting weight on his back.
Okay. And when he puts weight on his back, what had happened right previous to that, right? Officer Burbank gets bucked off of him, right?
Well, I think that's what the officer says he observed.
Do you see anything else on video, Mr. Ryan?
Well, no, because certainly when Ford and Rankin get there, it's not on video. So it can't be just right before.
Okay.
They wouldn't have that knowledge.
That's Officer Rankin's statement of why he moved into the position to ensure that Mr. Ellis was not going to get up, that he placed all his body weight on him so that when Officer Burbank got bucked off, correct?
That's correct. Totally inappropriate response.
Totally what?
Inappropriate response.
So, he's not in Mr. Ellis is not in hobbles yet, right?
Correct.
It's just the four of them out there waiting for officers to respond.
Correct. There's 4 of them and 1 suspect. Right.
And Mr. Ellis is trying to get up off the ground with those officers, correct?
That's what the officers reported.
Officer Ford is describing holding onto his leg as Mr. Ellis is kicking about, right?
That's what the officers reported.
Okay. They're giving verbal commands to Mr. Ellis.
Yes.
Mr. Ellis is not complying with any of those verbal commands, correct?
Again, there is some degree of noncompliance, whether it's conscious or unconscious noncompliance is a different issue.
Okay. And in that moment, that's when Officer Rankin says he's going to get up, and he jumps on top of him to make sure he's not going to get up, right?
That's what he describes, jumping on top of him.
Okay. And he says that they sit there until other officers can arrive. That's what he says,
He
right?
says he sits there waiting for other officers to arrive.
Okay.
In the first instance, he says that.
Right. And, I mean, you'd agree with me that when we're trying to put this together, we're looking at Officer Rankin's statement, right?
Correct.
And he's doing his best to describe what is going on in this scenario, right?
He certainly gave a statement as to what he did, which included putting this weight on the back.
Sure. And, I mean, he tells them why he did that, right?
He does. He articulates it in a report that he intentionally put weight on the back.
Okay. And in that moment, they're waiting for other officers to arrive, right?
Initially.
And we've seen on 898 when Sergeant Lim arrives, correct?
Correct.
And we know when Pierce County Deputy Sanders and Massanio and all those other officers that are listed on 898, I don't need to go back to it, but they arrive within anywhere from 30 seconds to 1 minute, right?
I think that's fairly accurate. I'd have to go back and look at it to make certain, but I think that's fairly accurate.
And in fact, Sergeant Lim talks about the fact that when he arrives on scene, he sees Ellis almost able, from that position, to put his knees underneath him and get up off the ground, right? With 4 officers on him.
I'd have to see that. I'm not sure he does it. He may, but I'd like to see it if you don't mind.
Happy to show you. I'll approach with Exhibit 710. And if you could refresh your recollection
Thank
with
you.
it, I will take this back.
Sure. He does say at one point, I observed the subject nearly get up on his knees. Not that he actually does, but he nearly does.
Nearly get up.
On his knees.
With 4 officers trying to restrain him, correct?
Yes.
And Officer Collins, when he talks about it, he talks about the fact that the only time he's experienced something like this before is with a guy who's on PCP, right?
Well, he described that when he was talking about superhuman strength. Yes.
And we know now after the fact, right, that Mr. Ellis had 2,400 nanograms of methamphetamine in his system, right?
I know he had methamphetamine. I don't have it committed to memory how much it was.
Okay. So Officer Rankin describes what he's doing. He describes that they sit there until other officers arrive. And then the next thing that he describes in his statement is he talks about, he says that other officers go and grab hobbles, right?
Correct. One of the officers actually called for a hobble first over the radio.
Officer Rankin never called for a hobble.
No, I don't think it was him.
Officer Ford, who's his partner, says, we don't carry hobbles in our car. Remember that?
That may be true. Some of the officers had them, some of them did not.
And Officer Rankin discusses the fact that he doesn't remember who put them on, but that they get put on, and at that point, Mr. Ellis is hobbled, correct?
Correct.
And we know that Pierce County Deputy Sanders assisted in putting the hobbles on, right?
He held his foot or something like that?
And he discusses him having his legs at a 90-degree angle, right?
Correct.
Okay. And then from there, there, Officer Rankin discusses the fact that they're going to do a weapons sweep amongst other things, right?
Correct.
So they put Mr. Ellis onto his side.
I think he actually says recovery position.
It does say recovery position. And we don't know exactly, obviously, when that occurs, right? The timing of all this is difficult. Would you agree with me?
I would agree that based on his statement, there's no timestamp on it.
Right. I mean, based on everything that you look at, there's no timestamp exactly. We could kind of piece it together based on the statement.
Well, there's some officers that get there and they say that the position doesn't change from the time they get there till the time they leave. I think Jones being one of them.
Right. Well, and Sergeant Rock being one as well, right?
Correct.
And
I
Sergeant
believe so.
Lim.
I don't know about Sergeant Lim, and the only reason I say that is because he indicates that he's only up by Mr. Ellis for a short period of time, and then he moves away.
Yep. And when he sees him also, well, multiple officers discuss seeing him in the recovery position, right?
Some officers see him in the recovery position, some officers see him on his stomach the time that they're there.
Okay. And back to Officer Rankin. So we know Officer Rankin puts him in the recovery position. We know that there's other officers on scene assisting as well, right?
Absolutely.
And from there, you said that, and I wrote down a couple things you said. You've used the word briefly, momentarily, in terms of that weapons sweep and the recovery position that Mr. Ellis is initially in. Remember using those words?
Yes.
Briefly and momentarily to describe the initial recovery position that Ellis is in appears nowhere within Officer Rankin's statement, right?
Correct, but when you take the whole statement in context, it appears to be that most of the time he was putting weight on him, on his stomach. Again, just the way he describes it. But I would agree with you that there's no timestamp on that.
Right. You don't know how long he's in. I mean, right now what we can piece together, right, is that in that position where he's got weight on him and puts his full body weight on him, we know that he says that he does that until other officers arrive, and that's the only timestamp we can put on it, correct?
But then he says he returns him to that position as well.
We're not there yet, but we're talking about timestamps for certain things.
Correct.
Okay. So we know that that's the only timestamp that we can provide on his statement.
On his statement, yes.
Right. And then we know from there that he's put into the recovery position.
Correct.
And Officer Ford discusses putting him in the recovery position almost like fairly quickly after that, right?
I'd have to go back and look. I don't know what he says from a time perspective.
And Officer Ford, right, they're partners. And Officer Ford is continuing to talk to Mr. Ellis throughout this incident, right?
I believe that there's officers trying to talk to Mr. Ellis, yes.
They're continuing to say, stay calm, right?
Well, I think you know, and again, I think it's Officer Rankin also says, if you stop and calm down, I'll take pressure off you.
You're going back in time, and I'm trying to walk through this thing chronologically. So right now, we're in the point where other officers have arrived, and Mr. Ellis is in the recovery position, and they're starting to do a weapons sweep amongst other things. You with me?
Yeah,
Well, you may answer.
I think certainly a weapon sweep. I don't know, I don't recall among other things.
Okay. Well, so you saying briefly and momentarily for this weapon sweep, those are your words, right?
Absolutely.
I mean, Mr. Liu used that in opening as well, briefly.
I don't know whether he did or he didn't, but that's based on my reading of the statement, which you'll have, I'm sure.
Okay. Would it help you to look at Officer Rankin's statement?
To see if he said briefly?
No, I think you know that he didn't say briefly, right?
I don't know. I'll have to look in how I got that context.
So I'll approach with 65K.
Yes, sir. Thank you.
So I want to have you flip to the page that he's discussing this, what he's doing in that note, right? And this is page bottom of page 15.
If it's all right, I want to grab some context too, please.
Sure.
Okay, so they also located the taser probes as well and removed those.
Jumping ahead of me.
I'm sorry. I thought that's what you were asking. I thought you were asking among other things.
No, yeah, well, we're going to get there.
Were you asking about briefly after all? Is that what you were asking
We're
about?
talking about briefly and
Okay.
recovery. So this initial recovery position, right?
Yeah, I don't see anywhere where he said it was briefly.
Okay. He doesn't say momentarily, right?
Correct.
All right. So he discusses rolling him into the recovery position, right?
Correct.
And he discusses doing a weapons frisk on him
Correct.
to ensure that he discusses checking his pockets, right?
Yes.
Front and back, making sure that he doesn't have any weapons on him or anything that's going to stick them or anything like that, right?
Correct.
And then, I mean, that's not the only thing that he does, right?
Right. They also removed the taser probes.
That's right. They see that he's been tased, and they start to remove the taser probes from him, right?
Correct.
And you would agree with me that removing the taser probes is a form of aid that they're starting to render to Mr. Ellis.
I don't know if we term that in terms of aid. The taser probes have to be removed. They're retained as evidence. I don't know that I've ever referred to it as giving aid. Giving aid would be if we were to treat them after removing them.
Okay. Well, there's something sticking in Mr. Ellis at that point, right? In his skin.
Correct.
And Officer Rankin wants to remove that from his skin, right?
Yeah, and again, I'm not sure whose statement it was in, but there's a question as to whether it was in the skin because there was no blood on it when he pulled it out.
Well, he actually specifically discusses that as well as what they're doing. So he says, first of all, he notices that he's really warm to touch. So
Correct.
we're talking about he's in the recovery position. He's done a weapons frisk on him, and then he notices that he's really warm to touch.
Yes.
Right? And he sees that he's sweating profusely on his hand.
Yes.
Right? And he then talks about taking off his patrol gloves as well.
Correct.
Right? And then he's putting on rubber medical gloves. And when he does that, he also notices that his gloves are kind of completely soaked, that he assumes that that is from Mr. Ellis.
I think that's the gloves he took off.
Yeah, correct. And then he puts these medical gloves on.
Yes.
Right? And then he says that they do this weapons frisk, and they start removing the probes as well, right?
Correct.
Follow along with me on 17. 16 through 17. And lines 3 through 8. Sorry, 3 through 13. Because he says the initial probe is embedded in his jacket, right?
Yes.
And the other probe is embedded. There's a second probe that he was able to locate that was in his left chest area, right?
Correct.
Okay. And that might explain why maybe, well, strike that. So he's able to locate that second probe. And he says that they remove it, take the needles completely out, make sure that there's no barbs still in him. That's what he says, right?
Correct.
And he can't remember certainly, but he thinks Ford was helping him for this, right?
Well, because he says that secure the probes as evidence. That's what I mean. It's not really rendering aid. It's evidence recovery.
I can't imagine that having probes in your chest is very comfortable, right?
I'm sure it's not if they've penetrated. I mean, it's not extremely uncomfortable. I've been tased before, but it's not comfortable.
I'm sure you wanted those removed afterwards, right?
At some point, yeah.
And then he talks about, well, I'm trying to talk to this individual as well. 19 through 20. Right?
Correct.
And he says when they're trying to talk to him, he starts violently thrashing all over again, right?
Correct.
And then he says, so we roll him back to his stomach, and they reapply pressure just to hold him down, right?
So it says, so I instructed the officers to roll him back.
Correct.
So he's directing the other officers as well.
All right. And the policy talks about control superiority as well, right?
Yes.
The idea that you need to maintain control of an individual.
Absolutely.
And even the sergeants talk about the best position to maintain control of someone is in the prone position.
I'll tell you what, once they're handcuffed, I'd like to see that in writing,
Okay.
because that would be totally inappropriate once they're handcuffed.
Okay. And they reapplied pressure just to hold him down, is what he says, right?
Correct.
And Officer Rankin's really detailed in that initial pressure that he puts on him prior to other officers arriving. He discusses the fact that he's putting all of his body weight, kicking his ankles out to hold him down, right?
Correct.
And in this scenario where he's talking about it, he says that he's just holding, just to hold him down. Reapplied pressure on him just to hold him down, right?
And he had gained control of his upper torso.
Right. He doesn't discuss putting all of his body weight on him again, right?
No, there's not that detail. But anyway, even just leaving him in the prone position is improper.
Okay.
So any pressure would be improper.
But it's in reaction again to Mr. Ellis continuing to thrash around. That's the reason he does it, right?
That's what he says, yes.
That's
Of course.
the reason he articulates.
Absolutely.
It wasn't for no reason whatsoever, right?
Well, he articulates that it's for him thrashing around, yes.
Okay.
Doesn't change the analysis.
Well, being able to articulate a reason is important, right, Mr. Ryan?
Well, you'd have to articulate a reason for any use of force. But again, it's inappropriate to put pressure on somebody's back after they're handcuffed. It's inappropriate to leave them in a prone position after they're handcuffed.
I also want to draw your attention to, well, let me ask you this. This statement's given on March 6th, 2020, right?
Yes, sir.
2 days after this incident.
Yes.
And Officer Rankin is clearly doing his best to describe all the things that he did in this scenario, right?
I would say yes.
Okay. And articulate reasons for why he's doing them as well, right?
Correct.
And we're talking about a dynamic and chaotic situation today. Do you agree with me?
The way the officers reported initially? Absolutely.
Okay. And Mr. Ellis continuing to thrash around also is problematic, right?
Again, bearing in mind, you've got a number of officers there now. So, obviously there's strength in numbers. So as more officers get there, it's much easier to control a person. And that's why we moved them to a rescue position to control.
And that's what he did initially.
He did it for purposes of the weapon sweep and for purposes of the taser. He doesn't say anything about doing it for purposes of facilitating breathing.
He talks about the recovery position.
He does mention it as a recovery position, which indicates that he knows that there is such a thing and that it's necessary.
Okay. And so then you try and figure figure out, right, how long, we don't know how long he's in that position in terms of doing all these things, in terms of the probes, the changing of the gloves, the weapon sweep, the noticing of him sweating, all those actions. You don't know how long that takes, right?
We don't from him.
Okay. And then you know that he obviously puts him back into the position and reapplies pressure just to hold him down.
He reapplies pressure, yes.
With other officers.
Yeah, I don't know that he identifies any other officers holding him down by his torso. He says he's the one who gains control of the upper torso.
Okay. And can you turn to page 31? Lines 12 through 16. They're asking their Officer Rankin whether he was injured at all. Do you see that?
Yes.
And in response, he says that his knees are a little sore from sprawling out, trying to hold the subject down as he bucked us off and kind of dragging us along the road, right?
Yes.
Indicating that his knees at some point are getting dragged along. It seems to be on the ground or that they're on the ground, right?
That would be indicative of that, yes.
But again, you don't know within this statement when you're trying to interpret when things are happening, when that happened, right?
No, but there's multiple points where he's putting pressure on his back while he's handcuffed, and it's inappropriate, particularly if you know there is such a thing as the rescue position or the recovery position.
That's not my question. So I'd ask that you just answer my question and start articulating what you want to say right now to the jury. Thank you. You don't know when that occurred, right?
When his knees are hitting?
On the ground.
No, it could be when he's laying across his back with his body.
And so you have an officer 2 days after trying his best to articulate all the things are happening, right?
Well, he certainly put a statement together, yes.
Okay. And you'd agree with me that there are multiple things within the statement that obviously you can't account for time, when, who's around, and what's occurred, right?
Well, we've got the timeline of when people are arriving,
Went through that.
but as far as his statement goes, we can't. We can only take statements of others who place it a long time by fire getting there or by him being in the prone position.
We also know, based on the timeline, the things that we do know, right? You talked about objective evidence. We know that Sergeant Lim called for fire, I think within seconds, well, I would say seconds, 30 seconds to a minute of arriving on scene, is that right?
I think so. It's certainly pretty quick, and one of the reasons was because of the taser deployment. It's required.
And we know that they're waiting for fire to arrive.
Correct. In fact, many of them complained that it took fire a long time to get there.
Okay. And we know that at a certain point, Officer Rankin places, with other officers, places Mr. Ellis back in the recovery position, right?
Correct. He says he does that as the fire department's arriving.
And he says that actually he stopped thrashing around as much anymore, right?
Correct.
And at that point, he starts taking his pulse as well.
Correct. I think he said he took his pulse, and his pulse was 80.
And he says that he talks about a previous incident where a biker got into a collision and they were checking his eyes. You remember that?
I don't remember that, but I'm sure it's in here. I'm not disputing it.
And so he says that they also had officers look at Mr. Ellis's eyes, right?
He may have said that.
And he also says that he's watching his chest rise and fall and breathe as well, right?
Correct.
You agree with me that checking Mr. Ellis's pulse is indicative of the fact that Officer Rankin is rendering aid to him and caring for his well-being, right?
Well, he's checking a vital right at the end, right when the fire department's arriving. I think that's the way he says it.
And that he's checked him for injuries as well, is what he does, right?
I think he might have done that earlier.
Yeah, he does do that earlier. So, and he says he notices that his knuckles are bloody,
Correct.
that he's got scrapes on his face.
Correct.
But he's checking him for injuries to see if there's anything traumatic in nature as well, right? Something that that's like life-threatening in that moment.
I don't know that he says that, but he does say that he does check him and sees blood on his face and on his hands.
Also indicative of the fact that Officer Rankin is caring for this individual, right?
Well, no, he's evaluating, but he didn't provide any level of care.
He's evaluating his injuries.
Well, he's documenting the injuries that he observed.
Okay. And when he's checking his pulse, he also tells his fellow officers that he's concerned about Mr. Ellis's pulse as well, right?
Can you show me that? I thought he said it was weird because his pulse was good at one point. Could be
Yeah.
mistaken, but
On 20 lines 11 through 13. He says, I remember saying out loud, well, that's really weird. His pulse is completely normal. Quote,
and then at the same time, fire was just walking up, so he checked it right as fire was walking up.
right. You know how long Officer Rankin was there for at that point?
I'd have to go back and probably the best way to figure that out is the timeline of fire, but I don't have it committed to memory.
8.5 minutes. 8 minutes, 30 seconds.
Yeah.
I've been doing this cross-examination for almost over an hour.
8.5 minutes, and a portion of that time is on his back, putting pressure.
You have no idea how long, Mr. Ryan.
Only from other reports of how long he was in the prone position.
And none of those reports indicate any concern that Officer Rankin was exhibiting too much force or pressure on Mr. Ellis, right?
I don't think another officer reported that, no.
Okay,
Is this a time to break?
sure.
Okay. Take your afternoon recess for 15 minutes, ladies and gentlemen. Please do not discuss the case among yourselves with anyone else. Thank you.
point, the court, with the jury being present, commented something to the effect, and I don't have the verbatim, because I don't have the transcript in front of me, but the court commented to the effect of, I don't think that's true, or that's not accurate, something to that effect. Would,
I did.
And the state is requesting that the court give a curative instruction to the jury that the court's comments on the comments are not the evidence.
I intend to give that instruction in the final instructions.
And I appreciate the court's intent to do that in the final instruction. The concern the state has is the timing of that with this particular.
I think he misstated the law.
And, Your Honor, if the court is of the opinion that he misstated the law and that the court has the right to be of that opinion, you could strike the testimony rather than, or take a different approach rather than comment in front of the jury.
I'm gonna include in the instructions that I'm not to comment on the evidence, and if it appears that I comment on evidence, they're disregarded entirely. So they'll get that instruction. They'll also get the instructions to what the law is.
Absolutely.
And then they'll put it together. So that instruction will be given, but I don't intend to give it now.
Well, if the state wants to strike his entire testimony, I don't think we'd have an objection.
Your Honor,
No, but the problem is, I still think he's wrong about the law. At least what we were talking about, the aspect that we were talking about at the time. And if I indicate somehow that I was in error, then I'm effectively saying he's right about the law, and I still don't think he's right about it.
Your Honor, so it's the court's position that the reasonableness standard, taking into consideration the officers on the scene, is not the correct standard?
That wasn't the issue, really. He was trying to say that the issue came up in the context of the hypothetical of an officer having belief of a weapon in somebody's hand, and then it turns out later it's a toaster. And I said, well, if he had a reasonable belief that he was looking at a gun, then he's supposed to act on his reasonable belief, as what would be objectively reasonable, but not what he's making objective. He's making objective sound like what actually happened, and what actually happened is there's a toaster, and therefore the officer would be wrong. That's not right. The standard is objective, yes, but the standard is a reasonableness objective, and it's based upon the perception of the officer at the time. And if it turns out his perception was wrong but reasonable, he's entitled to act on his reasonable perception. And I don't think he was saying that. I think he was saying he has to act on what it turned out to be, even though he made the point that it can't be 20/20 hindsight. So to me, he was talking to cross purposes about that issue.
I guess I understood the court to be addressing the legal analysis versus the hypothetical.
I don't know how you separate the two. The hypothetical was to illustrate or give highlight to what the legal principle involved was that he was trying to explain.
Is Your Honor willing to instruct the jury that, and I think some of it has come out in, I want to say Mr. Conrad's cross. It's been a long day between the three of them on who it came out with, but that, Mr. Ryan isn't here to testify or to provide the law. That's the court's duty. But I'm wondering if at this time, before we proceed, is the court willing to instruct the jury or tell the jury that the actual law will be instructions from the court?
That's already been actually asked of by one of the lawyers asked him. You realize, I think it was just actually Mr. Conrad said, the law is going to come from Judge Shoshkoff, right? And he goes, yeah, I agree with that. So there you go.
Your Honor, I think that just the concern the state has is that the jury take the court's comment as an indication not to believe Mr. Ryan or to denigrate his credibility.
Well, I didn't want to take it any farther than I did, but I think he was wrong about that, and I still think he was wrong about that.
Understood, but I mean, I guess the state's position is that the court could have told the courts.
What I said was,
The court may be right, but it's the case law is pretty clear. It's about whether or not the jury takes it as a comment on the credibility of the witness, and that's what the state is concerned about.
I didn't say he was wrong so much as I didn't think so. He said it was a certain way, and I says, well, I don't think so.
Effectively told them that you didn't agree with what he was
Yes,
saying.
in that one aspect, that's true, I don't, and didn't.
And we believe that that's a comment on the evidence, and we're just concerned about that comment and not
Sure.
addressing it now as opposed to later.
As I say, I've explained to you why I did what I did, and I've also explained to you why I think it would not be a good idea to do it now. So, we're done. All right, let's have the jury, let's have Mr. Conrad complete his cross. Okay, welcome back, everybody. Please be seated. Mr. Conrad.
So I wanted to show you Exhibit 746. Take this one back.
Sure.
Exhibit 746 is an interview that was done with former Tacoma Police Chief Aiken. I believe you reviewed this as part of the materials. You remember that?
Yeah, I do remember reading a transcript with his name on it.
Okay. Can we turn to page 64, please? Starting on line 18. This was an interview with former Tacoma Police Chief Aiken, and Mr. Blue is present there, John Tillman, who's an Assistant Attorney General, Dave Heitzman, who's an investigator with the Attorney General's office as well, right?
Yes.
Okay, Mr. Hillman asked Chief Akey there, he says, just to make sure I understand, until they're under control, the preference to keep them in the prone position.
Objection, Your Honor. I asked that he asked a question of the said just read the
I think we're getting there. This is a foundation. He's basically going to say, is this right or wrong, I think. So go ahead.
That's the question, right?
I'm not sure everybody heard it yet. Why don't you go back to the beginning?
Sure. So Mr. Hillman asked Chief Akey, okay, just to make sure I understand, until they're under control, is the preference to keep them in the prone position. Did I read that correctly?
Yes.
And Chief Akey says it could be. I don't want to say I know exactly every situation is the same, because it's not. But once, I think the whole purpose of putting someone on the ground and handcuffing them is to get positional superiority. And you and I have talked about that, right?
Correct.
That you know that the person is not going to harm you. That person is not going to harm others or themselves. So it's just a matter of trying to have a controlled environment as best as an officer can. That's what the chief said, right?
Correct. To get him on the ground to handcuff him? Yes.
Sure. But Mr. Hillman goes on and he asks, my question on line 12 there, further down the page, my question being, what's the policy or practice? If someone's handcuffed and leg restrained, as far as keeping them prone, face down. Chief Akey responds. Did I read that correctly?
Yes.
Chief Akey responds, I don't think we have, and I could be wrong. I don't know if a policy specifically covers that. What the procedure, we talked about it earlier, but based on the situation, whatever else we have, trying to move the person's positional fixture that you can still control and be able to have a better controlled environment. So I would say it's based on their situation and what we have of it. The officers try to make that determination, and I don't think we have a specific policy on it, but I could be wrong. Did I read that correctly?
Correct. They had no policy on it.
All right. And then if you flip to page 78. Line 10. Mr. Hillman again asks,
This is a proper impeachment of this witness. He wants to.
indicated that he didn't know that one of these.
Well, it isn't impeachment. He's asking because he evidently, he said he considered this in his opinions here. So I want him to compare and contrast them.
So if they're hobbled and handcuffed, this is the question, if they're hobbled and handcuffed and placed on their side, would there be any, and I know every situation is different, but any reason that you would return them to the prone position? That's the question from Mr. Hillman from the Attorney General's office, correct?
Correct.
And Chief Akey responds, I think if you put someone into the prone position and they're still combative, or the recovered position to the prone position, and someone was combative and still fighting, I could see that you do that temporarily to, have better control of the situation. But I think, and we've talked about it in two different terms, and we have been. One is that we do that, and we're fighting, and these things are happening, and then when it turns into a medical condition, right, there are two different criteria that takes place. So I think that's why we give our officers that great discretion out there in the field, using the different tactics, techniques. We want them to do the best they can with the information they know at the time. Did I read that correctly?
That's what he testified to, yes.
All right. One thing that I just wanted to make clear is the position and the timing of when Officer Rankin says that he initially places all of his body weight on him and evenly distributes it. And he said that obviously he did that until other officers could arrive, right?
That's what he said.
And then we see in 898 that other officers arrive within 28, 25 seconds, right?
That's correct.
Okay. You'd agree with me that placing someone into the recovery position is evidence that an officer is rendering aid and taking care of the suspect as well, right?
I don't know that I'd call it rendering aid, but it's absolutely what an officer is supposed to do, get the person off their stomach, get the pressure off their stomach, particularly after they've been restrained. officer should always, once you take somebody into custody, you have complete responsibility for their well-being. So a prisoner, that's the one time there's a complete duty. And so because of that, of course, you're going to be assessing them for injuries, illnesses, anything else.
Do you agree that the policy talks about modulating your force given the suspect's resistance or lack of resistance, right?
Correct. So modulating means up and down. So as the threat goes down, as the resistance goes down, then so must the force.
And continuing to control an individual is an appropriate use of force as well, right?
Continued control is an appropriate use of force. Yes.
And I want to talk, trying to move this thing along, I want to talk about the idea of collective force that you discussed. Again, you'd agree with me that there are about anywhere from 3 to 5 minutes of an altercation between Officer Burbank and Officer Collins with Mr. Ellis prior to Officer Rankin's arrival, right?
I don't know the length of time.
Okay,
We'd
but
really have to look at
There is
it.
a period of time, obviously, where Officer Rankin's not present and there's force being used.
Absolutely.
And your idea, this idea of collective force, that doesn't incorporate Officer Rankin into any use of force there, right?
Not into the initial force, no.
You've made a number of comments about, obviously, with regard to air hunger and breathing issues, right?
Yes.
And you indicated that being in, and correct me if I'm wrong, but you indicated that being in the prone position with hobbles alone will cause breathing issues?
Even being in the prone position in handcuffs, it's been recognized for years, 3 decades at least, that that's dangerous.
You agree with me that there is a dispute within the medical community whether that's actually true or not, right?
I don't know that there is anymore, that there's any significant dispute over it.
Well, are you aware that the jury has heard from Dr. Veal, a pulmonologist in this case?
I wasn't here for that.
Okay, but you're not a pulmonologist.
I am not.
Okay, and are you aware that Dr. Veal testified that restraint in the prone position with wrist connected to the hobbles without weight applied does not cause hypoxia?
I don't know if he testified to that or not.
Okay, but it seems like you
From
disagree.
a police practices standpoint, we recognize that it's dangerous, not from a medical standpoint. That's not what I'm talking about. From a police practices standpoint, we recognize the danger of it. Even some of the top people that took the opposite position have now reversed themselves and are providing training that it is dangerous.
Okay. Well, you also published an article in September of 2020 regarding this issue. Remember that?
I don't off the top of my head.
You don't remember in the article saying that in the course of interviews with law enforcement trainers, it became apparent that a number of trainers misunderstand the issues related to positional asphyxia and prone restraint.
I'm not surprised I said that.
Okay.
I think that was, and again, it was in response to a big case. I think I was interviewed, and that's what prompted the article.
Okay. So obviously you had interviewed law enforcement trainers and it became apparent to you that there was some misunderstanding regarding the issue, at least in September of 2020 when you wrote this article.
I would have to see the article. I think what it was a trainer was interviewed by like the Associated Press on a major case, and then I incorporated that into an article that I wrote. I don't think it was me interviewing. I think it was the Associated Press had interviewed a trainer who made a broad statement about that.
Would you remember where that trainer was from?
I don't.
Would it surprise you that in this article that you wrote, you said that they were from the state of Washington?
Wouldn't surprise me at all.
Are you aware that the medical examiner in this case, former medical examiner in this case, Dr. Clark also testified.
Oh, I knew he testified.
Okay.
I've heard his name. I don't know what he testified to.
We were not made aware that Dr. Clark, in fact, indicated as well that there are multiple studies on both sides that would provide evidence that prone restraint in a hobbled position with up to 100 pounds on an individual's back does not significantly cause any form of hypoxia.
I am familiar with those studies, and I'm also familiar with one of the leaders on some of those studies and how he has reversed his position in training that he's providing now.
Now,
Yes.
are you aware as well that Dr. Beal, the pulmonologist, indicated that if Mr. Ellis indicated in a calm voice that he could not breathe, that it would not cause him much concern?
I don't know that he testified to that.
Okay. But you do know that Officer Ford and Officer Rankin both indicated that they heard Mr. Ellis say, "I can't breathe," right?
Correct.
Right. And that that one thing that they found that was odd about it, that he was saying in such a calm voice in that moment.
I think they do say that, but again, they were aware that he was making that complaint, and they should have responded to that.
By putting him in the recovery position.
Absolutely.
Okay. Which Officer Rankin did twice.
And getting,
Officer Rankin twice put Mr. Ellis into the recovery position.
he put him in for the search and removal of the taser probes, and then when the fire department pulled up, yes.
Thank you. And through your training that you've done, one of the things that you indicated in the interview with us, you talked about Dr. Oliver from Wake Forest. Do you remember that?
Yes,
Okay. And we were talking about this term excited delirium.
correct.
I think it's referred to maybe agitated delirium at this state. I don't know if you're aware.
Again, it's not a term that most people still use. We talk about people that are in crisis as opposed to excited delirium.
Okay. Are you aware that it's one of the bases for why these officers were charged in the probable cause statement?
I'm not sure I understand the question anyway, but I'll sustain the objection, because he's already discussed his lack of information with respect to the probable causes statement.
So in our discussion about Dr. Oliver, you said that the bottom line is that there are people that law enforcement run into that have an underlying condition that if you sent them out to shovel snow or climb the stadium stairs, they would die.
Correct.
That was your statement to us during the interview.
Absolutely.
Okay.
I object at this point due to a prior ruling from the board.
I'll excuse the jury and we'll talk about it. Ladies and gentlemen, please excuse us. Please do not discuss the case. I don't know what this question's about, and I don't know what the prior ruling it might be implicated for, so.
I appreciate that, Your Honor. The court previously restricted the testimony of any law enforcement to the symptoms that they may have observed on excited delirium, and were not permitted to offer opinions regarding the fact that it could cause sudden death or that it would result in sudden death, unexplainable death. That was, the court wasn't permitting law enforcement officers to go down that path. And it appears from where Mr. Conrad is going, that is what he intends to elicit from Mr. Ryan. And if I'm wrong about that, I just wanted to make sure we weren't getting there in front of the jury.
I don't think Mr. Ryan even agrees that excited delirium is a real thing. It's kind of a constellation of symptoms that it's difficult to explain. So I'm not going to use the term excited delirium. More the concept that officers encounter individuals that, like he said in his interview, they sent them out to shovel snow, climb stairs. They're these vulnerable individuals, I would say, or that have these underlying issues that die.
And I think that gets to the same point, and the court said in your prior ruling that if there's going to be some suggestion that Mr. Ellis died because of something called excited delirium, now we've got a problem, I think, unless there's some other doctor that's going to say this is a real thing, and then having this with going through his practices, I mean, you could certainly ask if there's different, like I did yesterday and correct about it's a medical crisis, you treat it as a medical crisis, not that it's gonna result immediately in death. Or something that gets renamed and causes a sudden death.
I honestly can move on from this. It won't cause me much issue.
Well, I think out of some bigger context, that's an unfair question of the witness. The whole thing, though, that if you ask some people, you might ask, "Go shovel snow," and they might drop dead.
Those are his words.
I understand that, but it depends on what the context is. I mean, one of the things that I've been puzzled about by everybody in this case a little bit, not so much the state didn't go there, but that the defense hasn't. They've barely touched on this. They've touched on it a little bit. Is this idea that if, as the state's position, as the defense position rather, is that Mr. Ellis was suffering for some kind of methamphetamine psychosis. I believe that's what you're saying to some extent. Certainly, you've suggested that in a lot of our motion practice and so on. Now, I haven't heard too much in the way of questioning about it. Then it may well be that Mr. Ellis would there be unreachable suggestion that he would be potentially, the word excited delirium suggests that they're being motivated by something that is outside the reality of their situation. So they could be panicked in an extraordinary amount of fear for one reason or another. If, for instance, I'm not saying this is true of Mr. Ellis, but if somehow a couple of people went to try to restrain me, we see this sometimes with medical aid people, that you try to restrain somebody because you're trying to take them to a hospital and they punch out the guy who's the medical person who's trying to care for them. They're not being arrested, but they're in some kind of delusion about what this person's trying to do to them. And as I say, there's been this suggestion that Mr. Ellis may be in a methamphetamine psychosis because he was apparently on another occasion before all this, and that therefore things that were going on as far as the officers were concerned wouldn't be in a way objectively explainable. He would be behaving in ways that seemed irrational, and that would add to panic, and that would add to fear, and those things would drive people's heart rate, oxygen use, and so on. But none of this has really been talked about in front of the doctor, so I don't know to what extent any of this matters. But I can certainly understand, because this idea of excited delirium, and I wasn't sure entirely myself what all that was. I've heard it before, but I wasn't sure what it was much before this case either. But if it is simply a different way of describing the fact that somebody is panicked and fearful beyond any kind of rational explanation in terms of what everybody else is seeing. I sometimes put it this way: if you are in a room and you jump out the window and you hurt yourself, and people ask you why did you do it, and you say because the green monsters were about to eat me. Nobody else saw any green monsters. That would seem like an irrational act. But if you really thought something was about to eat you and be devoured, jumping out the window may well be a very rational act. But it's in response to a delirium in a not real situation. I mean, I don't want to make this sound silly, but I mean, if somebody is under in a paranoid or otherwise irrational sort of fearful state, they do things. We certainly have had circumstances where people, because of delirium, shoot somebody because they think that they're kind of harm them. I had a case a year or two ago where a guy thought he was a spy and thought there was some things going on, and he set fire to his motel room and the motel where all the people were living. Of course, it was all in his own head. None of it was real. So people are capable of doing all kinds of things because of what's going on in their brains. Now, so to the extent as this ties into this excited delirium thing, well, I don't know what the context is of that particular response that Mr. Ryan gave, but if it has something to do with the idea that a person that police officers encounter from time to time exhibit behaviors which are inconsistent with the reality of what they're dealing with, that's of what the suspect is dealing with, the person they're trying to contain is dealing with, then that's something that is a real thing that officers have to do experience, and they can describe it. My view was, I think, with respect to this motion in limine, was that I didn't expect that use of force experts would be talking, if you will, about excited delirium as a medical condition and what symptoms it might be, but it could certainly be described in an indirect way in terms of what level of force might be appropriate when someone is displaying certain behaviors that seem irrational or so on. But as I say, there's been, and or that their aggression might be otherwise explained by use of drugs as opposed to anything else that they're actually experiencing. So my view was, to the extent it's a medical condition, if you will, and one in some dispute, but then we shouldn't be referring to it by non-medical or lay people in that way as if it's a real medical condition. But some of the symptoms associated with the description of excited delirium are things that police officers encounter and that suspects sometimes display, and that could be talked about in that way. So that's where I was coming from. So, as I say, picking this thing up out of I don't know what the complete context is about. You could ask somebody to run some stairs and they're going to collapse. Well, I mean, that's certainly true that any of us could walk down the street and immediately suffer a heart attack and die. And if you're exerting, that explain more. A friend of mine was actually on one of those stress test deals for your heart and had a heart attack while he was doing that. So taken out of some context, I don't think it's fair to the witness. But the idea that officers have to deal with people that don't seem to be behaving particularly rationally, and to the extent that maybe Mr. Ellis was that way, describe the symptom, describe what you see, describe what you heard. That's all fair game. But a medical opinion that just so lumps all this into excited delirium by non-medical folks or lay people, no. So the question itself didn't talk about excited delirium directly, but it was, of course, set up in the context of mentioning it first, so it kind of did. Anyway, so I would say that we'll strike the last question and answer, and then you can continue your examination. Anybody have any additional comment about it? No? Okay. No. All right, let's have the jury back. And Wake Forest is a university, right? Not something out of a Hobbit story.
What did I say?
You just said Wake Forest. You know? I'm not sure. I mean, I know what Wake Forest is, but I'm not sure how many people do. It's not a local university. Oh, we've blown past that line a long time ago. Well, Mr. Conrad, you got a Mrs. Winnie's list now. Messing up her exhibit book. Okay, welcome back. Please be seated, everybody. Okay, hold on, ladies. The last question of witness, last question and answer rather of the witness is struck, and the jury should disregard it. Next question.
Last couple of questions. Part of the information that you reviewed was also Lieutenant Wilson's report, right?
I'm sure.
And one of the things that you indicated was that when the paramedics arrived, that they asked that the hobbles and the restraints be removed, right?
Correct.
And in response to that, Officer Rankin indicated that he had some concern about doing that,
Yes.
right? And that his concern was that they had just gotten into an altercation and a fight with Mr. Ellis, right? And he was worried about removing the restraints, that Mr. Ellis started to become violent.
Well, I think he says that, but obviously when paramedics need to work on a patient, you've got to follow their direction.
Right. And he indicates that when Lieutenant Wilson, the paramedic, asked for the hobbles to be restrained, he looked to the Sergeant Lim, and asked, "Is it okay? Should I have it?" Right.
Correct. That's what he says in his statement.
And then where Lieutenant Wilson indicated that conversation really lasted just a couple seconds, right?
I don't recall the timing, how long it was. It was a short period of time. It didn't last very long.
That securing the scene and having an individual like Mr. Ellis secured at that point is critical in order to have paramedics even arrive on the scene, right?
Absolutely. They generally stage if the scene is not stable. They don't come to the scene. In this case, they did come to the scene because law enforcement had called them to the scene.
And that interaction between Officer Rankin and Lieutenant Wilson did not in any way delay rendering aid to Mr. Ellis in that scenario. You aware that Lieutenant Wilson said that?
I think it happened too quickly to have delayed it beyond a few seconds.
Okay. And are you aware that the location where this interaction took place on 96 and Ainsworth, that location is actually the last street of the city of Tacoma the city of Tacoma boundary limits. Did you know that?
I did not know that.
It's the furthest point that you can go for city of Tacoma officers as well as Tacoma Fire Department as well. Do you know that?
When you say furthest point you can go from where they're located,
From within the city boundary.
so it's the edge of the city,
Correct.
not necessarily mileage-wise from the fire station to there.
Correct. Did you know
I did not know that.
Okay. One last thing that I failed to ask you about. When we talked about, this is Exhibit 65A, Officer Rankin's statement. I've turned this to page 18. We talked about, obviously, we're trying to piece together certain time frames as to when things are happening, because it's not obviously very clear when certain transitions are being made, right? We talked about that.
Based on his statement, correct.
Okay. And so, and I want you to orient yourself with page 18, where we are within the sequence of events. You can look at page 17 as well. Now, I'll ask you a couple questions about it.
So this is after he did the sweep
Yeah.
and took the probes out
Correct.
and actually had regained control by putting pressure on him again.
Correct. So we're at the point where obviously other officers have arrived, right?
Correct.
Mr. Ellis is in the recovered position, and they're rendering aid, or they're taking the probes out, right?
They had done all that on page 18. He's already out of that position. He's back in the prone position.
Well, and that's and it's interesting, right? Because on lines 19 through 23, and I just actually noticed this on 19 through 23, Officer Rankin's talking about rolling Mr. Ellis back onto his stomach and reapplying pressure on him just to hold him down until fire could get there, right? That's what he says,
Correct.
right? And so we know this is where he's going from having him in the recovered position to reapplying pressure because he's been Ellis starts thrashing around, right?
Right. That's at the bottom of page 17 and the top of 18.
And then Officer Rankin says, I remember him, Sergeant Lim, getting on the radio and asking what's fire's ETA to our location, and dispatch responding with, I'll check, right?
Yes.
Okay. So we know that at the time that Officer Rankin is rolling him back onto his stomach to reapply pressure for him just to hold him there until fire arrives, that at that moment he remembers his sergeant asking for an ETA, right? For when fire is going to get there. That's what he indicates.
He indicates what, obviously he goes through a number of points, but on the previous page he talks about getting him back on his stomach and getting control. He says it at the top, and then at the bottom he doesn't say the exact time, but he said once we rolled him back over and reapplied pressure to hold him down, I remember Sergeant Lynn calling and asking for the ETA.
Okay, so in that moment in time, he remembers Sergeant asking for ETA fire.
After he had got him controlled into the prone position again.
Okay. It sounds like, based on the statement, right, we're trying to interpret what he says in this moment, correct?
Again, he says he put pressure back on him and reapplied pressure.
It's actually contained within the same sentence. There's a comma there, not a period, right?
Right, but he says it at the top as well.
Sure. So, what I want to show you is Exhibit 569. In 569, are you familiar with that?
It's a timeline. I'm not sure whose timeline this is.
I'm going to object to this as testimony regarding this timeline.
As I understand it, this is the timeline produced by Lieutenant Brockwood to Dr. Clark.
That had issues on the recording of the time.
Some.
Not on this one. I can grab a different exhibit. I know where it is.
Okay.
Ooh, those are strong words. Bingo. Okay. Exhibit 18. Well, do we have 18A? Is it up here? Yes, 18A. Can I approach, Your Honor?
You can. This is admitted for illustrative purposes earlier.
It was, and I don't intend on publishing it. I just need the timestamp for when Lieutenant Lynn asks for an ETA on fire. And if you flip to the last page, Mr. Ryan, you see it 23, 32, 39. You see that? And it says TPD 092.
Yes, Sam 092, give me an ETR on fire.
Yeah. And if you look at the first page, TPD 092 is Sergeant Lynn, right?
Yes.
Okay. So we know at 23, 32, 39, they're saying, give me an I don't know why it says ETR, but ETR on fire, right?
Yes.
That's what Sergeant Lim is saying at that moment. Right?
Yes.
Okay. So based on Officer Rankin's statement, the time period in which he is now, so he's taken the probes out, he's changed his gloves, he's checked him for injuries, he's all in the recovered position, all in that point, and he discusses that around the time period that he's placing him back into the prone position to hold him down until fire arrives, that's when he hears Sergeant Lim asking for an ETA.
At 23, 32, 39.
Okay.
And then it's, I don't know, a minute and a half later, 23, 34, 04, when they tell the sergeant that fire's pulling up.
Okay. I don't have any other questions.
Redirect.
Good afternoon, Mr. Ryan.
Good afternoon.
I have a few different areas I want to hit with you just to clarify a few things that defense went through, so it may not go as far as smoothly as far as the areas I'm hitting, but you jump it around a little bit, so please bear with me. You were asked some questions by Mr. Rosser regarding elbow strikes from his client defendant Collins to Mr. Ellis. When you reviewed the video, are you able to tell if it's elbow strikes or closed fist?
I'm not. I see strikes, but I don't know whether it's the elbow or the fist.
You were also asked a few questions regarding Exhibit 301, and I'm going to just have Corey, if you could just provide that for the witness only, please. And on the questions on 301, which is the TPD policy for use of force, you were asked some questions about active resistance and compliance techniques. Do you recall those questions?
Yes.
From multiple defense counsels?
Yes.
And how does the proportional use of force play a part in that aspect?
Well, it has to be proportional to the actual resistance that's taking place. So active resistance can be anything from the person arming himself with a weapon and going after the officer to simply pulling away. So you don't get to use the same degree of force on somebody pulling away as you do somebody that pulls a weapon on the officer in order to actively resist. So there's a range of active resistance, and it still has to go to the rest of the policy. It's got to be reasonable under the circumstances and necessary.
And when you go through, and Corey, if you can bring it to page 9 of 13, and when it goes through the duties and responsibility of any officer who applies any, and it's listed in defensive tactics on page 9, but it's throughout the policy, what is the duty of the officer regarding the injuries for the suspect?
So the officer responsibilities initiate post-application procedures, notify a supervisor, refer to actions in the incident report, look for and identify and document all visible injuries, inquire of and document complaints of non-visible injuries.
And that's inquire of the suspect or the person that's detained?
Of course.
And then at the bottom of that page, you were asked some questions by defense counsel Fricky regarding whether or not this case of the quote that he used, there is deadly force does not include force that is not likely to cause death or serious bodily injury, but unexpectedly results in death or serious bodily injury. And you testified on cross-examination that that wasn't this case.
Correct.
And can you explain to us why that's not this case?
Because law enforcement's aware that putting somebody in a prone position in handcuffs, leaving them there, and more importantly, putting pressure on their back, does create a foreseeable risk.
I'm going to allow this overruled. We're talking about EPD procedures.
You can go ahead and
So go ahead.
So again, because law enforcement is aware of the dangers of it, it's certainly foreseeable that it could likely cause.
Your Honor, I would object to that characterization.
Well, you may disagree with it.
Do that as well.
Well, that's fine. But that's not a basis for an objection. Overruled.
please continue.
Well, that was my answer.
Sorry, got interrupted, but I wasn't sure you were done. And the training and the police practices includes not to put the weight on the back, as you said, and not the prone position. And with that, I want to bring your attention to Exhibit 4, excuse me,
Move to
7.
strike comments from counsel.
The jury should disregard the comment of counsel and ask another question. Mr.
Exhibit
Nicolabo.
746, please. If I can have that for the witness. And that was previously testified to, that is Assistant Chief Akey, well, at the time, Chief of Police Akey's interview with the AGO.
Yes,
Do you recall, Mr. Conrad had you go through that?
yes.
Okay, and I'm gonna ask you to take a look at what would be, bottom of 76, and then carries over to 77, top of 77. And when you get done reading that, I have a question for you on that first.
Yes, go ahead.
Okay, and based on Chief Akey's interview, what do they teach the
Your Honor, and I'm going to ask to be heard outside the presence.
Okay, well, it's now 4 o'clock, so I'll excuse the jurors, at least for the day. And ladies and gentlemen, please do not discuss the case among yourselves with anyone else. Do not permit anyone to discuss the case with you in your presence, and of course, avoid any reports on the subject matter of this trial and wherever they might be found. And we can talk about this after the jury departs. So we'll stay in session for that. Do you want hold on, do you want the witness excused?
Yes, please.
Please bear with us, Mr. Ryan.
You want me to go outside now?
Yes, please. Don't go away, just go outside. Okay. Okay, Mr. Calavo.
Your Honor, the state specifically asked about the bottom of 76, which is
Right, can they put it back on the screen here for me?
pre-incident training, and did not inquire about post-incident training, which is noted before that. So the pre-incident training, according to Chief Akey,
Well, you're now responding to the objection. I'm not even sure what the objection
I
is.
think that's where he was going on that, serving for policy change or training change, and this is not.
But you're going into specific training, and he indicates in this interview that he's confused as to what the training is at the time versus what the training is afterwards. And I specifically stayed away from training. I said, let's talk about policy. And those are the questions that were asked that I elicited from him. I stuck with what the policy is. And in this interview, if you read the full thing, he says, you know what? I don't really know because they've had so many trainings since then. And so he doesn't know at the time. If you read through the whole thing, that's exactly what he says. And this court has previously said that trainings post-incident are not fair to implicate some type of knowledge on these officers.
Your Honor, it's the state's understanding that this portion of it is pre-incident. In addition to that, he also talks about positional asphyxia training that occurred prior to this incident.
And you're
Which is
going
on-
into training.
Yeah, I mean,
And we're not going to.
I'm sorry, what he says, what I read on page 76, on lines 6 through 8, it says, Kent, I'm so glad you said that because that reminded me, we just took a training, and I think it was through, and then he goes on. And I don't know the date of this interview is, but
Well, if you back up to line 2, the question from Mr. Liu is, is there any now? Do you now have any policies regarding when officers hear a suspect or arrestee indicate, I can't breathe? Is there anything to address that?
And I'm not asking that, Your Honor, that's why I'm saying, because then we go.
No, I know, but I think the question is in all the places. I'm so glad you asked that because it reminded me, we just took a training, and I think it was through, can't remember where that training happened, but it was a virtual training that our department just went through, and it was covered exactly that. And it covered something to the effect of when someone says they can't breathe, and even though they're talking to you, they may be having an emergent situation regarding their capabilities to intake oxygen. So there was a training that happened probably in the last quarter of last year regarding that situation. I don't know when this was taken, so
This is January of 21.
so this would have been the last quarter of 20,
Right.
right? So after the incident. And then Mr. Liu says, okay, and is that required training for all officers? Or was this a voluntary training? I'll have to find out if it was required. I'm going to say it was required. Okay, was there any type of training regarding that topic prior to this particular training that you're talking about? Yeah, see, we're talking about policies and training regarding officers' weight on top of someone as part of our prone handcuffing tactics and control tactics. We teach an officer to use their weight on top of the subject as part to control the subject who's combative or actively resistant. And I think that's best practice throughout the country. However, once they're in a handcuff position, officers are taught to place a subject on their sides so they don't remain in the prone position. So that does happen, and I just want to make sure I clarify. Also, same thing with the railing restraints, Once we do that, we try to put that person in the upright seated position or on their side. And we call that the recovery position. And that's sort of the expectation for even back last year. Well, I know that's the expectation now, right? But I think to say that would be best practice even before we did this, I would say yes. So he's not a paradigm of clarity. But it does seem to be suggesting that at least before the training the last quarter of 2020, that was kind of the expectation. He's kind of saying that. But that's still potentially, there's still another 6 months there or so where.
Your Honor, I would say that even before we did this, on that page 77, when he goes through and says, and I think that's the expectation now, right? But I think to say that would be the best practice even before we did this, I would say yes.
Well, I just read it. But the way he says it, he says, well, I know that's the expectation now, right? But I think to say that would be the best practice even before we did this, I would say yes. Like, I'm not sure. That's how it reads. He said it, yes, but he'd said like, but not certainly. I don't know. So that's your objection, though, Mr. Conrad?
Yes, Judge. And I can't find my version of it for whatever reason. But there are other comments by him, and there's an attorney that's present there, Mike Smith, and he indicates within this interview that he's like, you know what, we need to figure out what the actual trainings are for the time period in which this occurred. We need to go nail that down for you all, and we'll get back to you on that. And those are, I mean, that I think that's in the beginning of the interview. I'm trying to find those.
Well, here's my executive ruling from the blue sky. Try to find it between now and tomorrow morning. It seems to me that the way it reads, at least so far, if I don't have any other information, is that he said yes. He said it kind of, and you can pick up on that on cross-examination if you care to. Now, if you find elsewhere in the interview that it's even more equivocal than this, well, I'm perfectly willing to reconsider it. But that's why I say find that between now and tomorrow morning. If you don't find it, I'm going to assume that the answer is, yeah, that was the training. He said it kind of uncertainly, and you can point that out. But
I mean, the court's previous ruling was we're not going to get into training, right?
well, no, I didn't say it quite like that. I said the Attorney General's office couldn't use whatever is subsequently being trained to try to suggest some misconduct or even bad motive on behalf of the defendants if they were operating within the training they had at the time. And so the training that may have occurred post this event, they certainly can't be held to a standard like that. And yeah, there may be a little confusion by Chief, is it Aki? Is that how you pronounce it? Aki? Is, as I say, not a model of clarity, but he does seem to be saying he believes that was the training, in so many words, pre this event. And if you can find me elsewhere in the interview where he's even less certain of that, or changes his mind about, well, in the end, I really don't know, or something like that, well, then I'm perfectly willing to revisit this. You got till tomorrow morning to find that and point it out to me.
I think if it's not in this, I'm almost positive he says it, and if it's not in this, it's in his sworn deposition testimony where he's asked about trainings at the time.
Well, if you find that, we can go from there. And I don't know whether or not, I'm assuming his deposition would have been post this interview. Because it looks like this interview did not have any defense lawyers at it, right? Correct. This was an internal interview by the Attorney General's office.
We did a defense interview with AG present, I believe, with AG, with everyone there.
Sure, later.
If we did, we'd love to have a copy of it, because we haven't been allowed to have contact with them.
The city would not allow us to talk.
Didn't we all do an interview with?
No, the defense did a deposition.
I don't know, and I don't really care about that. All I'm just trying to say is if there is some other
There's another transcript out there, that'd be great.
transcript or disposition that says something different from this, that's fine, and we can consider that too. But, in all fairness to Ms. Nicolavo, if there's something out there like that she's never had the opportunity to look at, you can't blame her for that.
I'm probably getting the deposition mixed up because that's in these materials too that they're citing for the deposition.
Well, that's why I say I'm gonna wait till you do this, wait till tomorrow morning, and hopefully you can sort this out and we won't be guessing.
Appreciate you taking the time, Your Honor.
Okay. All right, is there anything else, everyone? All right, enjoy your,
Just one quick issue, is that we did file an offer of proof with respect to Russ Hicks. I know that the court
I see that.
hasn't had an opportunity.
well, at least so far, I'm not hearing any reason why I should visit this again.
I just wanted to check if he's out of state. I didn't fly him here. If you'd like to know.
Do you think there's a good reason to change my view? I mean, you didn't like the view in the first place, I grant you that.
In the first place, that he should have been permitted to testify.
Right,
So our position's just the same.
all right, but do
To
you,
the actual training, and I guess
is
the
it,
court's not gonna allow it, which I understand, but I think that as a result.
well, my position was, and you were accurate about that, which was, if in the course of the examination of Mr. Ryan, issues came up which made Russ Hicks's testimony pertinent, then I would revisit that and we could have him back. So far, I haven't heard anything that would change that. And I guess my question to you is there anything you can point to that maybe I'm missing that should change my view? Not the old stuff, not the reason you wanted in the first place, but is there anything about the way the examination has gone? I kind of imagine, Mr. Purchase, that was your position.
One of the reasons the state's position that Mr. Hicks should be allowed to testify is because the defendants were trained on positional asphyxia, and they were trained on the risk of it, and trained on what Mr. Ryan has been testifying to. They've been trained on.
Well, I don't want to get into the weeds on that, but at least the testimony so far is that Burbank and Collins were not involved in any positional restraint once, or virtually once, Mr. Ellis was hobbled. So then we're talking about Rankine. And Rankine acknowledges recovery position, that kind of stuff, in his own statement, as has been mentioned two, 3 times. Right? So it's not like, and of course, Mr. Ryan is of course asserting that as to any police officer conducting any kind of an arrest, and if we get Chief Akey's statement in that we were just reading about, then you'll have it in there too. I don't still see why we need it from Hicks as to what the specific training was.
It also goes through the prone restraint. They are taught that the prone restraint can lead to hypoxia, which is consistent with what Mr. Ryan is testifying.
Well, yeah, but, and he's already told us what police say, but we've also heard from the medical people who will all say,
And here's the problem too, Judge.
Not so much.
Then produce the training. I've looked at all the trainings. I've looked at every single PowerPoint, every single training guide. There is nothing contained in any of them that indicates that. Chief Akey doesn't have the basis of knowledge about what occurred. Call Travis Waddell, who trained my client from Control Tactics at TPD. Call him.
you're inviting the state to do that.
Do it.
Well, Your Honor, I guess the concern that we have is that, we understand that the court has said we don't need it and that the cross has not really gone there. However, I guess the issue that I would raise still is that the defense shouldn't be permitted to argue a closing argument that they weren't trained on these issues. And they haven't gone into it, but that's what we're concerned about, is that we put on Jack
Well,
Ryan.
if they put on evidence about how they were trained that suggests that this is all wrong, then Hicks could conceivably be called back in rebuttal.
Understood, if they don't, and instead they lay in wait, in closing, argue, the state didn't put on any evidence that these officers were actually trained in any of these concepts. So I think it's just fair, assuming that they don't go there with their witnesses, that the court not allow them to make that argument in closing argument.
I don't know, all I know is that you've got Exhibit 301, the procedures, talks about what you can do and not do. We've got Mr. Ryan saying what that means and why. And I guess there's going to be a use of force expert from the defense. Was there?
Yes, and what I see the state doing now is they're opening their own door, right? They're trying to bring in training. It's not even proper rebuttal.
Well, now, hold on a second. I mean, with all fairness to them, they wanted to bring it in, and I said no because it wasn't particularly relevant. unless and until there was some dispute about what policy they should have followed and didn't. And at the moment, and that therefore this training would then, and Mr. Hicks would then respond to that. So far, I'm not hearing that there is anything that says that there was anything about their training they shouldn't have followed. You may, I suppose you could have a use of force expert that says, when Mr. Ryan says the business about asphyxia, positional asphyxia, is part of their training, and you've got somebody that says, no, it isn't, well, then as I said, maybe we get Hicks in to say, I know this is what they got trained on, and so there you go.
I don't think we anticipate that happening, Your Honor.
Right, but Ms. Eakes' specific question is a little different. It is, okay, you can't say what they weren't trained on, or were trained on. Well, to me, I suppose it's maybe a little bit like a malpractice suit. I mean, doctors are held to do to certain basic competencies, and we know what the policy is in terms of the procedures for effecting or using force that the city's got. It seems to me the city, if they say, well, it seems to me the state should be able to argue from that alone sufficiently. But if you can say, we didn't know because of training, I suppose that's one thing. I'm not really sensing that that's where the defense is going with this. Where it seems to me where the defense is going is, that one, positional asphyxia didn't cause Mr. Ellis's death. Two, even if it did, from Burbank and Collins's point of view, there's no evidence that we did anything to affect his positional hypoxia until, because we just got him secured and we didn't do anything, and it was minutes later before the medical aid arrived, and we had nothing else to do. And so therefore, this was all part of their motion originally, the Napstead type motion. And so therefore you can't hold us responsible for all that. And Rankine isn't saying that I didn't know some of these issues, but I'm monitoring him. The amount of time he was on prone was actually fairly small based upon the information we've got out of his own mouth from this deal. And finally, that what is it specifically about Mr. Ellis's condition at the instant, or in the instances, in the minutes just before he died, which would have alerted anybody, other than him saying that he couldn't breathe, that would have alerted anybody that he was actually facing this kind of a problem. I mean, someone can say they're not breathing, and it could be true, and that could be a reason just to do it. And there isn't some. I'm not sure if you got into this or not. I think I read something about it today that, and maybe it was in Akey's deal, that or maybe it was in Mr. Ryan's, that you need to. Our training now, and at least as in part, is we got to take it seriously when someone says something like that. I don't know if that got in front of the jury or not, but what would be the sign that Mr. Ellis was in that much distress, just as opposed to being merely out of breath, just like Burbank and Collins were, as a result of the fight?
Well, Your Honor, at the very least, the evidence that Mr. Ellis said over a period of 2 minutes that he couldn't breathe. It's not as if he said it
could be.
one time. And
No, that's all right. That's why, that's why there's their jury. But it isn't, I don't see that's why I see the defense shaping up here. Whether I'm right or wrong, I don't know, but it doesn't really turn on, I wasn't trained for that and therefore I'm not responsible for it. They really kind of say that there was nothing about the circumstance that suggested anything different from what we did do. And therefore we're, one, not responsible for his death, and there's no, as a result of no proximate cause for his death with respect to Burbank and Collins. And with respect to Rankin, they were saying, in so many words, there was no condition or thing that they did which was negligent or reckless that produced the death of Mr. Ellis. Now, there's evidence that the state's producing, obviously, can be interpreted a different way. But all we're talking about for the moment is what's the defense position here. It's not about training.
Well, I guess what I would say about that is that whether the court is right or wrong about exactly where the defense is going, the state has the burden of proving the charges beyond
Sure.
reasonable doubt.
That's all true.
And part of the state's obligation is to prove that they acted in a reckless manner because there's there's manslaughter in the first degree as one of the charges.
Reckless or negligent, yes.
Correct. And to the extent that you are trained on something and you disregard your training, such as prone restraint, positional asphyxiation, putting weight on somebody while they're down on the ground, goes to the issue of whether or not you're acting recklessly. That's the state's position.
Well,
That's why we believe
as I say,
training is important.
if they bring up training in their evidence, then there you go. Then you could potentially bring Hicks back.
Understood.
Mr. Connor, you can have whatever pained expression you want, but I mean, if the issue comes up, the state's entitled to go there.
No, I get that, Judge. I guess my frustration is this, that the state is presenting, it seems like uncertain opinions from Chief Akey about what the training exactly was at the time, without actually bringing forth the people that actually did the training.
Well, you guys objected to it.
So we objected to it, right? Because Hicks didn't train our client, and we said bring in Rich Lee, bring in Bob Bragg, the people that actually train them. They don't want to do that. They want to bring in a plaintiff's use of force person, and then they're going to admit. So we stay away from training. I don't cross on it at all. And now Ms. Nicolava wants to get into training as to what it was. Well, the proof is in the pudding. Put forth the actual training then. Put it forth. Call Travis Waddell. Call Rich Lee. I don't have issues with those people, but my issue is with Hicks himself, because I think we're just going to open a huge can of worms in this, and I think it's unfair that they're going to make this implication when they're actually, it's almost like the idea behind the best evidence rule, right? Which is
I don't know. I have to tell you that I'm a little flustered because it's like, flustered's the wrong word. I'm a little confused. I mean, Mr. Rankine testified in his statement to the Pierce County Sheriff's Office, talked about wanting him to be in a condition of recovery, right? That's all the training goes to, right? So this is, everybody's arguing about stuff, but I'm like, why?
okay.
The training here, with respect to this, I mean, the state wants to make this a bigger issue with respect to Burbank and Collins, I think, more than Rankine, because Rankine acknowledged, I felt like you need to put him in a recovery position. Why? Mr. Ryan said as much. Well, it suggests that Officer Rankine knew he should do that. And that was one of the questions was asked in direct as well. He mentioned it in cross. So, I mean, it's gotten out there a couple of different times. And now there's a hassle about what they were trained on. I mean, I don't know. The training as to Rank and Collins is fuzzier, but it's like, there's a part of me that just says, so what? Because Burbank and Collins made it pretty clear they had nothing to do with it after that. The state wants to tie them in for that responsibility for having a continuing duty of supervising them and so on. Okay.
Understood.
Look, Your Honor, as the court knows, we've asked to put in the training evidence, and I've articulated the reasons why we think that it goes to that.
Right,
I hear what the court is saying right now, but
And Ryan has said, this is what they ought to do. This is what trading is. And there's all this business about, what anybody would be trained on, and there was no indication that there's been no indication in the cross-examination that the kind of training that Mr. Ryan was talking about that officers would receive didn't actually happen.
understood.
Right.
As I have said to the court all along, I mean, I understand that the court is taking the position that certain evidence shouldn't come in if you think issues aren't contested, but we have to prove it to a jury, and for purposes of the jury, we have the burden of beyond a reasonable doubt. I know defense counsel wants to tell us who the witnesses witnesses should be, but the state has the right to call the witnesses that we want to call and prove the case.
Well, up to a point, that's right. And you've had over 20 witnesses, so.
We had planned for 80-something.
Yeah, well, I had 132 at one point, I know.
Well, I never said we'd call 132.
You had a list of 132 you submitted officially, and I said, you got to cut this down. You got it down to 82.
That was for the jury question.
And then the last I heard, you were going to add another 10 or 15 to that. So, anyway, so getting it down to less than, I don't know, let's call it 25 or so, from 82. Good job.
I appreciate that the court thinks that that's beneficial to the jury, but in any event, that's,
Well,
it sounds like the court's not, we don't need to have Mr. Hicks here tomorrow because the court hasn't changed his mind. That was my main.
I don't, based on the testimony, based on the examination we've received so far, I don't think it's necessary.
Okay.
As I say, if it,
They want to stand by it, if they want to raise the issue.
exactly right. Okay,
Thank you.
We good?
I think we're good.
Thank you.
Take care.
Thank you. Have a nice evening.
You're welcome. You too.